The most relevant and important piece of legislation relating to human resources is the Fair Work Act 2009. Whilst this legislation applies only in the Australian context, governing bodies in most labour markets will have similar rules and procedures to follow in order to maintain a healthy balance between the rights of employers and those of employees. The Fair Work Act of 2009 is a cornerstone of employment law in Australia, setting out the rights and responsibilities of employees, employers and organisations. For a workplace manager, understanding key aspects of the Act is critical for compliance and human resource management. Here are some key takeaways from the Act. Number 1 is the National Employment Standards, or NES. The NES are 10 minimum employment entitlements that must be provided to all employees. This includes maximum weekly hours, requests for flexible work arrangements, and parental leave, among others. Next is modern awards. These are the industry or occupational-based minimum employment standards that apply in addition to the NES. They cover wages, penalty rates, types of employment, flexible work arrangements, hours of work, rest breaks, and dispute resolution procedures. Number 3 are enterprise agreements. These are collective agreements made at an enterprise level between the employer and employees about terms and conditions of the employment. They must meet the Better Off Overall test, or BOOT test, when compared to the relevant modern award. Next is unfair dismissal. The Act provides protection for employees against unfair dismissal, setting out the criteria and process for claims. Managers need to understand the fair process for termination to avoid legal repercussions. Number 5 is the national minimum wage. The Act sets out the minimum wage that must be paid to employees, which is reviewed annually by the Fair Work Commission. Number 6 is workplace flexibility. The Act provides provisions for employees to request flexible working arrangements under certain conditions, such as parental or carer responsibilities, which managers need to fairly consider. Number 7 is transfer of business. The Act outlines the rights and obligations of employers and employees if a business is transferred. This includes recognising certain entitlements when transferring employees. For more detailed analysis of the Act, you can refer to the legislation website, which is legislation.gov.au.